For today's United States Supreme Court case, we turn our attention to another redistricting case, in the case of Moore versus Harper, which deals with issues of redistricting and also deals with the question of who can raise those complaints to the United States Supreme Court. Can the Speaker of the House of Representatives bring the complaint, or does it have to be some executive branch official? What is the role of the House of Representatives in raising these issues? So let's go ahead and get started with this. The election clause of the federal constitution requires the legislature of each state to prescribe the rules governing federal elections. This case concerns the claim that the clause vests state legislatures with the authority to set rules governing federal elections free from restrictions imposed under state law. So this is the idea of only the state legislature can prescribe the rules dealing with election. There's no role for the state judiciary, no rule for the state executive. Under federal law, only the legislature can act. So this is this independent state legislature doctrine, deeply controversial idea. I don't think the Supreme Court's going to go for it, but this is the idea, right? The Constitution says the legislature of each state prescribes the rules, and their argument was literally only the legislature, no role for state executive, no role for state judiciary, literally only the legislature. The legislature gets to act alone, independent state legislature. So this was one of these theories that had been percolating around in some of the more conservative circles, but not an idea that I ever prescribed to. It didn't make sense to me. But some of the hardcore right people really like this idea. I'm not sure they should, incidentally, because that would mean that, legislatures that would be opposed to them would be able to do whatever the hell they want, but I digress. Following the 2020 census, North Carolina's General Assembly drafted a new federal congressional map with several groups of plaintiffs challenging the map as an impermissible gerrymander. The trial court found the partisan gerrymandering claims non-judiciable under the state constitution, but the North Carolina Supreme Court reversed. So the trial court says, I can't review this. And the state Supreme Court's like, yes, you can. You can review whether this is improperly gerrymandered. But now it's the state Supreme Court issuing a decision that says, yeah, you can do this, but can you? Because under federal law, maybe it's the legislature acting alone, and there's no role for the North Carolina Supreme Court. That has been the argument. Okay. While acknowledging that partisan gerrymandering claims are outside the reach of federal courts, the state Supreme Court held that such questions were not beyond the reach of the North Carolina courts. So partisan gerrymandering is been said there's no judiciable standard to say whether or not it's been gerrymandered as a matter of federal law. And the states are like, well, we'll give it a try and say maybe we can say as a matter of our state law that we can judiciate it as a matter of our state law, but maybe there's no role for the state government to play here. The court also rejected the argument that the federal elections clause vests executive and independent authority in the state legislature to draw federal maps. So this is that independent state legislature doctrine. Only the state legislature, literally only them. In this context, the legislature is the executive and judicial branch all rolled up into one. So in this context, the state legislature would be king because they'd be all three branches brought together. And only the federal government would have any power over them. And the federal government's already declined to review this issue, so there'd be nothing for the state to do. The court enjoined the use of the maps and remanded the case to a trial matter for remedial proceedings because the North Carolina Supreme Court's like, we have power. The legislature then filed an emergency application in this court, citing the election clause and requesting a stay. The court declined to stay, but later granted cert. So we will take a look at whether the North Carolina Supreme Court has any power here as it relates to state law. After this court grants cert, the North Carolina Supreme Court issued a decision addressing a remedial map adopted by the trial court. So the trial court was still, the North Carolina legislature was still churning along because there had been no injunction issued by the U.S. Supreme Court. So there had been no stay, right? So yes, it got appealed to the U.S. Supreme Court, but there was no stay. So the North Carolina courts are like, okay, we're just going to keep churning along. So continuing to churn along, the North Carolina Supreme Court validated a map that was drawn by the state trial court because the thing was still proceeding. North Carolina Supreme Court then granted the legislative defendant's request to rehear that decision. The court ultimately withdrew the opinion, concerned that the remedial maps and overruling a different case, repudiating its holding that partisan gerrymandering claims are justiciable. The court dismissed the plaintiff's claim but did not reinstate the 2021 map struck down. This court has entertained 2 rounds of supplemental briefing on jurisdictional questions in light of state court rehearing. So can a state court hear this kind of case? Okay. Held, this court has jurisdiction to review the judgment of the North Carolina Supreme Court that adjudicated the federal election clause issue. So there is a constitutional provision for the Supreme Court to review, so fine. A corollary to this court's jurisdiction over cases and controversies is there must exist a dispute at all stages of review, not merely at the time the complaint is filed. The North Carolina Supreme Court decision to withdraw a decision and overrule a different decision does not moot this case. So the Supreme Court of the United States believes there's still a live controversy despite what the North Carolina Supreme Court decided to do. Okay. Prior to appeal and rehearing proceedings, the court had already entered judgment and issued a mandate, and the legislator defendants acknowledged they would remain bound by the decision in joining the use of the plans. When the North Carolina Supreme Court overruled its decision as part of the rehearing process, it repudiated the conclusion that partisan gerrymandering claims are justiciable under North Carolina Constitution, but the court did not purport to alter or amend the judgment in joining the use of the map. So the Supreme Court of the state said, we don't have power to review this, but didn't change the decision that they used. So they previously said, we had power to change it, and then changed it, and then said, we don't have power, but didn't change it back. So the map still exists, despite the fact that they didn't have power to change it. So the judgment still exists despite the lack of underlying power. So the Supreme Court can adjudicate the map. Okay. Were this court to reverse some decision, the 2021 plans would again take effect. Because the legislature defendant's path to complete relief runs through this court, the parties continue to have a stake. Okay, so we've satisfied the standing problem and say, yes, they're still standing because the North Carolina Supreme Court repudiated its own power, but didn't repudiate the decision that it decided based on the power that is now repudiated. So the decision still stands despite the fact it says it doesn't have power. So we need to adjudicate the map. Okay. The court also has jurisdiction to review the judgment under a different law, which provides jurisdiction in this court, extends to final judgments rendered by the highest court of a state. Fair enough. Because subsequent proceedings have neither altered the analysis of the federal issue nor negated the effect, the issue has survived. Yes, they're still standing. Okay. To the merits, the election clause does not vest exclusive and independent authority in the state legislature. So, yeah, all the people who are uber panicked about the hard right, in this independent state legislature doctrine can relax. And the North Carolina Supreme Court can presumably reverse itself again. The North Carolina Supreme Court almost certainly reversed itself because it didn't want the Supreme Court to review it, but didn't go all the way. So now that they've gotten all clear, I expect the North Carolina Supreme Court will reverse itself. So we were wrong. No, we were right. So, now that we've got power. Okay, so the elections clause does not vest exclusive authority in the state legislature. So this independent state legislature doctrine is a non-starter. Marbury versus Madison famously proclaimed this court's authority to invalidate the laws that violate the federal constitution. But Marbury did not invent the concept of judicial review. State courts had already begun to impose restraints on state legislatures even before the Constitutional Convention, and the practice continued to mature during the founding era. James Madison extolled judicial review as one of the key virtues of a constitutional system, and the concept of judicial review was so entrenched by the time the court decided Marbury that Chief Justice Marshall referred to it as one of society's fundamental principles. Yes, in contra to Nick Rekieta, I believe that Marbury versus Madison was correctly decided. So we do have a split of opinion among the law tubes. And I believe Nick Rekieta is not alone on this. I don't remember who else is with him. But I believe there is a split of opinion in the law tubes as to Marbury versus Madison. I believe Marbury versus Madison was correctly decided. But, you can talk to Nick Rekieta about that, and he will happily rant about it, I am sure. The elections clause does not carve out an exception to this fundamental principle. When the state legislature prescribes rules concerning federal elections, they remain subject to the ordinary exercise of state judicial review. So, yeah, state legislatures can still be reviewed by state courts. In Ohio, ex rel. Davis versus Hyberdent, this court examined the Elections Clause application to provisions of Ohio Constitution that permitted the state voters to reject by popular vote any law enacted by the state General Assembly. This court upheld the Ohio State Court determination. The Federal Elections Clause did not preclude subjecting legislative acts under the clause to a popular referendum, rejecting the contention that to include the referendum within state legislative power for the purpose of apportionment is repugnant to the Elections Clause. So, yes, the voters can also directly vote on this issue and exercise legislative authority themselves. So, to the extent that the state allows for state voters to do things by petition, which is often a thing in California, for example, and in this case, Ohio, to the extent that the law allows for voters to create law themselves, they are, in that moment, the legislature. So, yes, the legislature continues to exist in the Capitol building, but the people, being sovereign fundamentally, can yerk that power back and be like, no, we're the legislature now, screw you. And that works as far as the Supreme Court is concerned, no problem. And in Smiley versus Holm, this court considered the effect of a governor's veto pursuant to authority under the state constitution of congressional redistricting. The court held that the governor's veto did not violate the Elections Clause, reasoning the state's legislature execute of authority under the Election Clause must be in accordance with the method the state has prescribed for legislative enactments. So no, the legislature doesn't get to just poof this law into existence. The Constitution of the state says this kind of law, like kind of other laws, has to be signed off by the governor. I suppose it doesn't have to say that. There could be some exception in the state constitution because states can kind of do whatever the hell they want. So they could give unilateral power to the state legislature to just do this by joint resolution and call it a day. Well, technically, it would be a concurrent resolution, not a joint resolution, as I correct myself, because technically a joint resolution would have to be signed off by the governor. That's the difference between a concurrent resolution and a joint resolution, as I law geek my ass off over here. So we can't just do it by concurrent resolution and just magic it into existence. It does have to be signed off by the governor because our state constitution requires it, and that's fine by the U.S. Supreme Court. This court recently reinforced the teachings of the case law in cases concerning the constitutionality of Arizona ballot initiatives to amend the state constitution and invest redistricting authority in an independent commission. So Arizona also has a process to take things out of the legislative hand by direct vote action, direct democracy. And the voters are like, we don't like the state legislature because they suck. We want to make it independent. And the Supreme Court's like, yeah, you can do that too. I know that the state legislature is in the building over there and all, but, at the moment, the people are the legislature, so screw you guys, because the people are fundamentally sovereign. The people outrule your ass. So, yeah, you're the legislature, but not for the moment. Sucks to be you, because the people are voting. Significantly, for present purposes, the court embraced a core principle espoused in different law. Whatever authority is responsible for redistricting, the entity remains subject to constraints set forth in the state constitution. The court dismissed the argument that the Elections Clause divests state constitutions of power to enforce checks and balances against the exercise of legislative power. So, yep, if the people want to directly vote and they want to be the legislature and they want to enact laws, then, and the state constitution says that's cool, and they do that, then, sorry about, being elected and all, but you have no power right now because the people have yanked it away from your asses. And you can't go bitching, but federal elections clause, though. Supreme Court's not here for that. The basic principles of these cases reflected in the unanimous command that the state legislature may not create congressional districts independent of requirements imposed by a state constitution with respect to enactment of laws commands that respect. So, no. The precedents of this court have long rejected the view that legislative action under elections clause is purely federal in character, governed only by restraints in the federal constitution. So this clause gives power to the state legislature, but that doesn't mean that the power is purely federal in its nature, and there's no role for the states here. The states have the authority to create this through the legislature, whatever that means to you, state. What is the legislature? It's up to you to decide what the legislature is, right? So if you say the legislature is these body in the state capitol, then great. If you say the legislature is us, the voters, then great. And if you say by the state constitution those enactments are reviewable by your Supreme Court, then great. Great. You're doing the republic democracy thing. You have created a government that it works for us. We see no problem with this. So yeah, there is state power here. The argument to the contrary does not account for the framers' understanding that when legislatures make laws, they're bound by the provisions of the very documents that give them life. Yeah, there is no state legislature, but for the state constitution that makes it so. The state legislature does not exist, but for the state constitution that makes it so. So, the state constitution says, hey, there's a legislature, but it has other words, right? It has other words about, an executive and a judicial branch, and sometimes has some words about the voters and the people and direct referendum. So, yeah, a legislature, we're really thrilled that you exist and all, but, you can't just be like, hey, we're here and we have unlimited power, because the very document that says you get to exist also constrains you. So, with the bitter comes the sweet, with the good comes the bad deal. Thus, when a state legislature carries out its federal constitutional power to prescribe rules, it acts both as a lawmaking body created and bound by its state constitution, as in an entity assigned authority by the Constitution. Both constraints exist. So yes, the legislature has to do this. But yes, you're bound by state law. Deal. The court's decision in a different case, which the court analyzed under the Constitution, similarly worded election clause, is not applicable. That decision does not address any conflict between state constitutional provisions and the state legislature. So yes, there is some law that deals with the electors and how electors get appointed and when electors act. So electors voting in the electoral college. Hey, there's something, right? The electors vote for the president. Okay, great. So we have some case law dealing with the electors, as one would expect. And that case law dealing with the electors is super interesting and all, but doesn't have very much to do with this clause of the Constitution. So go away. That decision did not address any conflicts between the state constitution and the state legislature, nor does a different case, which involved a contested vote by a state legislature to ratify a constitutional amendment, help the petitioners. That case concerns the power of the state legislature to ratify amendments to the Constitution, which is yet a different clause of the Constitution. Hey, should we have a federal constitutional amendment? Here's a process for going about doing that. Here's how you do that. Well, geez, what does that mean? Let's go interpret that. Well, whatever that means doesn't have a lot to do with this. But fashioning regulations governing federal elections unquestionably calls for the exercise of lawmaking authority, and the exercise of that authority is subject to ordinary constraints. So what is the lawmaking authority? Is it that building in your state capital? Is it the people? Is it something else? Is it that independent commission you created? Right? That independent commission you created, they're the legislature now. Right? We still have the building in the state capitol. They're cool and all, but they are not the legislature, says Arizona. Arizona said that building in their state capitol is the legislature most of the time, but not for the purpose of drawing district maps. Hey, legislature in a state capitol, you are not the legislature anymore. These guys are now the legislature. You can't do that. We're the legislature. Supreme Court's like, yes, they can. Yes, they can. Now they have two legislatures. They have two legislatures. They have a legislature for this purpose and they have a legislature for this purpose. They can have as many legislatures as they want. They can have a whole group of legislatures, each one of which only has power over certain things. They can do it any way they want. Screw you guys. Petitioners can see that at least some of the state constitutional provisions can restrain a state legislature's exercise of authority under election clause, but they read the case law to differentiate between procedural and substantive. But neither case draws such a distinction, and petitioners do not in any event offer a defensible line. So they're like, okay, the case law speaks to procedural, not substance. And the Supreme Court's like, well, no. And also, you don't differentiate it. So no. Is there a difference between procedural and substance? Yes. Did you figure out what it is? No. So go away. Historical practice confirms that state legislatures remain bound by state constitutional restraints. Two state constitutional provisions adopted shortly after the founding expressly constrain state legislative action. So, the states, when the Constitution was brand new, were still doing this. So that's at least somewhat informative as to what the founders might have had in mind. In addition, mobile state constitutions at the time of the founding regulated the manner of federal elections by requiring that elections shall be by ballot. We could do elections some other way. I mean, we don't have to do elections by ballot. We could do elections by some other way, but we thought, what if people voted? That seems like a good way of doing it. What if when they voted on these like pieces of paper or something, and we counted the pieces of paper? That'd be cool, but we don't have to do it that way. We don't have to, but we did. So let's count the pieces of paper. That sounds fun. Moreover, the Articles of Confederation, from which the framers borrowed, provide that delegates shall be annually appointed in such matters the legislature of each state to direct. The fact that the Supreme Court is citing the Articles of Confederation is kind of hilarious. I'm not sure when the last time the U.S. Supreme Court cited the Articles of Confederation is, but it's got to have been a hot minute. The U.S. Supreme Court has done some really interesting things with citations recently. The U.S. Supreme Court recently cited Magna Carta, which isn't unheard of, but is pretty rare. And now they're citing the Articles of Confederation? Holy shit. When was the last time the United States Supreme Court cited Articles of Confederation as authority? Holy God. Every sovereign citizen out there just got a little bit of a boost in their life because this U.S. Supreme Court just cited to the Articles of Confederation. I look forward to the sovereign citizens citing this case as propositions that the Articles of Confederation is still good law. Does the U.S. Supreme Court understand what it just did? Does the U.S. Supreme Court understand with this, wow, this is going to work with the sovereign citizens? Oh my God. When's the last time that they cited the Articles of Confederation? Holy shit. Fine. Although the Elections Clause does not exempt state legislatures from ordinary constraints imposed by the state law, federal courts must not abandon their duty to exercise judicial review. This court has an obligation to ensure state courts' interpretation of state law do not evade federal law. For example, states may not sidestep the taking clause by disavowing traditional property interest. Yeah, so we said that, when you take property, you have to provide just compensation. And the Supreme Court actually had to deal with the hypothetical, hey, what if a state says this just isn't property anymore? So we only have to pay just compensation if it's property, but what if it's not property anymore? Then we don't have to pay just compensation, right? Because it's not property. U.S. Supreme Court's on to you, sir. You can't do that. You can't just abrogate the property out of existence so that you don't have to pay just compensation. No. States' courts may not transgress ordinary boundaries of judicial review, such as they aggregate to themselves power vested in the state legislature. Court not need to decide whether the North Carolina Supreme Court grade beyond the limits as petitioners not meanly preserved. Roberts delivers the opinion of the court in which Sotomayor, Kagan, Kavanaugh, Barrett, and Jackson join. Kavanaugh concurs. Thomas dissents, in which Gorsuch and Alito join. In a 6-3 opinion. Thus, that brings us to the end of the coverage of the case of Moore versus Harper, a case that the left was really concerned about, and you might have heard in the news because of this independent state legislature doctrine. It definitely got some news reports along the way, so I wouldn't be surprised if you had heard about it because there were a lot of people concerned the Supreme Court was going to go full independent state legislature doctrine. But I didn't think they would, and they didn't. They decided that, yeah, the state legislature is still bound by its own state constitution, including, its facts about how it does stuff. So the North Carolina Supreme Court probably going to unrepudiate itself in the very near future because it only repudiated itself to get around the United States Supreme Court, but it didn't do it all the way. So it would probably unrepudiate itself and go back to what it was. And I imagine other courts will look to perhaps deal with political gerrymandering on a state level. So that would be something that states could do, perhaps through petition. And some states might do that to end political gerrymandering and put that as part of their state constitution. So apparently you can do that now, or at least the U.S. Supreme Court hasn't said you can't. So yes, the state legislature is the body to create maps, but what the legislature is up for the people to decide and is bound by the state constitution. And the federal elections clause does not change that. And that, for the moment, brings us to the end of discussion of this case.